harm or threat to harm limits the scope of the Attorney General.
No, Your Honor, not as to liability, and not in cases like this where what the Attorney General is seeking is injunctive relief and disgorgement. Greenberg for the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here. And remember to think about the illegality claims as well, because it's not just fraud.
Did you very finish the question?
So for the illegality claims, you look to the underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent and there's materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
So that's you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender, perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money. And that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that whatsoever for liability. And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Counsel, an example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes,
it didn't affect the public, at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
Well, I'll say two things, Your Honor. Well, first of all, the limiting principle are what's in the law. So the illegality claims require intent. They require materiality.
Let's talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather broadly, but there are still limits. It is not falsity in the wind, first of all. It is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand. And it does have to have a capacity or tendency to deceive. It has to have a capacity or tendency to deceive. And I will stress, Your Honor, that this does have harm to the public and to the markets. And I think what Your Honor is saying is that in some of the other cases, the ripple effects happen to happen. It went so far that the ripple effects from fraud went on to hurt the market. But what the legislature wanted was 6312, just like for the Martin Act. And the Court of Appeals talks about this in assured guarantee.
To be prophylactic, is that what you're about to say, counsel?
Yes, look at the assured guarantee case from the Court of Appeals. It talks about how a big point of these statutes, not the only point, but a big point is for the Attorney General to go in quickly to stop the fraud and illegality before it gets to the point that counterparties are harmed or it has those kinds of ripple effects in the market. I do want to, though, push back on the idea that Deutsche Bank never complained and wasn't harmed at all. Deutsche Bank did complain. When they first found out about the alleged misstatements and omissions, they raised serious concerns with defendants, said that misstatements in the financial statements would be an event of default. They asked for more information, and when they didn't get more information, they exited the entire relationship with the Trumps. That shows that they cared about the financial statements being truthful and accurate.
What year was that in? What year was that in?
It was right when they first heard about the allegations. So I believe it was 2020, Your Honor, although I'd have to check the precise year on that. And Mazars as well, when Mazars found out about the alleged misstatements and omissions, they also sent a letter saying these financial statements should not be relied upon anymore. So it is not true that the counterparties didn't care or never complained, even though that's not required for 6312.
I'm sorry. Go ahead. I'm moving off topic, so if you have a question on this, go ahead. maybe a better topic than mine. Back to Justice Moulton's point about line drawing, because I do think that is very important in this case. You know the history of this statute. It's passed under then AG Javits, and then was really amplified by AG Lefkowitz over the years. And when I went back and read the bill jackets, the common thread was always we need greater power. The AG needs greater powers as the people's lawyer to protect consumers, civil rights, and the environment. And so again, with that sort of historical backdrop to this law, how do we draw a line or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312, and when she is going into an area that wasn't intended for her jurisdiction?
Sure, Your Honor. Well, I will say, although there was certainly concern about consumers, especially at the outset of 6312, in some of the legislative history, there were multiple bills being passed, and some of them were more specifically consumer protection statutes, which I think explains some of the focus. And the legislature wrote this statute. It doesn't say consumers in it. It wasn't focused. I mean, of course, we want to protect consumers. I'm not saying otherwise.
It does start off with the words to honesty and integrity in the commercial marketplace. So,
yes, Your Honor, and it also is it says quite broadly, whenever any person engages in fraud or illegality, whether that is meant to include businesses large or small, because this kind of deceptive risk does cause problems for the honest business people who don't do it this way and don't get the ill-gotten gains. And it does inject risks into the market. I mean, Your Honor, there was probably a time when most of us didn't know what a repo 105 was, which is what brought down Lehman, or what a RMBS was. And maybe, in an ideal world, the Attorney General or somebody else would have gone in and stopped that fraud and illegality when it was still just among the sophisticated counterparties and before it had the enormous harms and ripple effects that it ended up having.
So let me just ask you, you mentioned about the ripple effect, going on. If the threat of harm or whatever the ripple effect is so remote, does the conduct fall still? I mean, how remote does it have to be? It's the same question with regard to this line drawing in order for the AG to follow through.
I mean, I think the remoteness problem
until it's outside of the scope of the statute as intended.
Sure. I mean, I think at least for 6312 fraud standing alone, I think the limit does come in through the capacity or tendency to deceive requirement. I don't think that the legislature wanted to have this kind of evaluation about the precise harm out of a specific transaction. I mean, that's why harm is an issue that might be for restitution, but that's not an issue here. But there is a limit, and it comes from the tendency or capacity to deceive standard that this court has put on that does incorporate a materiality-like standard. I think when we say materiality is not required, we're talking about the reasonable investor, that materiality is not required. It's just which objective person you're looking to. There's still an objective standard. So there are...
That's a good point. And so which objective person are we looking to here, given that it is the nature of the transaction that it is? I don't want to belabor the background.
I mean, it doesn't... This court has said that the standard for 6312 fraud standing alone is the objectively reasonable, ordinary, and even unthinking person. But in this case, the court could use the higher standard and it would be fine. Because
I notice you say the ordinary standard on page 55 of your brief. You say these deceptive strategies had a capacity or tendency to deceive because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Mm-hmm. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
Well, if the court wants to use the standard of an objectively reasonable counterparty, sophisticated counterparty, fine. They had a capacity or tendency to deceive the sophisticated party as well, because these misstatements and omissions were about objective facts that were extremely important and that any reasonable counterparty would want to know. Any sophisticated reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive. And even defendant's own expert at summary judgment, this is at 16502 of the record, agreed that the restrictions would decrease the value of Mar-a-Lago, but defendants valued it as if those restrictions didn't exist at all.
Counsel, I want to ask my question because your red light is on.
Absolutely, Your Honor.
Madam PJ, is that okay?
Yes.
For the disgorgement calculations, wouldn't it have been more appropriate to calculate them by calculating the difference in valuation of the property versus the valuation provided to the banks to get the loans?
No, Your Honor, the disbursement calculation, what we needed was the reasonable approximation. What is the reasonable approximation of what defendant's fraud gained them? And defendant's theory is that the guarantee and the financial statements each year were worth nothing. But the point of the guarantee and the financial statements each year was to get the extremely favorable interest rates. And we were not speculating about the difference in interest rates. We had the counteroffer that Deutsche Bank, their own lenders, provided them for a loan without the guarantee and the financial statements. I do, if I could touch very briefly on the statute of limitations, Your Honor.
Did you have another question?
I have a question that's
And I'll
similar
give
to
you
Judge
time,
Rosado's,
please.
actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?